department if there is a matter of business and others of notice.
Yes.
Please, the court. With the court's permission, in the time that we have, we would split what we wish to say into 4 sections. The first is this, that if my lords and my lady think it would be useful, it would be to respond directly to my Lord Justice Moylan's request for a brief overview of the case, the structure, the architecture of the case. We can do it briefly in about 10 to 12 minutes with a free run, if the court thinks it would be something of assistance.
I think so, yes, please.
But the second will be to look at the law of nuisance. Some might say that it was a big ask for this court, for my learned friends to make detailed legal submissions yesterday on the law of nuisance without first systematically setting out the framework that's been provided for the modern law of nuisance by firm and Tate. That framework, we respectfully submit, will be of immense help to the court. The third section is to look at the specific grounds of appeal. That won't take long, 10 to 15 minutes. And then the fourth section, my learned junior, Mr. Mitchell, who is the only one of the counsel before the court who appeared below, will address ground 4, negligence, and he tells me it's 30 minutes, no more.
Thank you.
So an overview. We start with the pleaded case, which is in the particulars of claim, or many particulars of claim, are in the core bundle on page 200. And if your lordship and my lady look to paragraph 9, in fact, the heading is at the bottom of page 201, bottom of the previous page, the heading is background. And in paragraph 9, sets out the background, which starts with saying, since 2003, the normal and ordinary use of the claimant's land has been for the breeding of falcons. And that background then follows for the next few paragraphs. And then paragraphs 10 to 18, the background is in that paragraph 9. And then 10 to 18 is about the defendant's knowledge of the risk to the falcons and an agreement to avoid it in the previous year. And the paragraphs that follow set out more of the background and more of the allegations of that knowledge. We then get to paragraph 20 on page 204, which are the particulars of nuisance, the scaffold and the like. And in paragraph 21, the paragraph starts by saying, the above activities at paragraph 20, A to H, did not constitute general and ordinary use of the second defendant's land. Then negligence is pleaded, and then from paragraph 23, harassment is pleaded. There's also an allegation, it's a statutory tort, and then malice, but neither of those arise on this. And then, if the court would go to page 215, there's the amended defence and counterclaim. And that basically denied the claims and pleaded a counterclaim in harassment. So it was being said that the claimants harassed the defendant as well. None of that's relevant. What became at the heart of the way that this was defended is at paragraph 26 of the defence and counterclaim, page 222. It's right at the bottom of page 222. And what it says is, further, even if, contrary to the defendant's case, it were to be established that the defendants knew that the construction of the barn and other acts would have an adverse impact on the breeding of the falcons, ignore what it says about malicious, nor would the same have constituted a nuisance. That's what became the heart of the way it was defended, and it was also very much what my learned friends were saying yesterday, that this couldn't have been a nuisance. Then, on the 24th of December 2024, there was a summary judgment application by the defendants, which relied on the sensitive user point, which is what this paragraph 26 is getting at. It can't be a nuisance without a sensitive user. It relied on the sensitive user point to seek a summary dismissal of the claims in nuisance and negligence. The way it was put was, this is tantamount to a restrictive covenant on the defendant's land. And the judge alludes to that summary judgment application and alludes to that tantamount to a restrictive covenant point at two places in his judgment, paragraph 135 and paragraph 160. That failed, and on the 17th of January last year, 2025, there was a site visit. Solicitors, counsel and the parties walked around both plots of land. It's referred to in the judgment in various places, including at paragraph 25. They went inside the aviary to see the pens and the falcon sightline, and they saw where Mr. Hode's digger was towed to and left 3 days after it broke down. And the judge, of course, was on that site visit. The judge raised questions in the normal way, and the parties answered them in the normal way. That was 17th of January, 6 days before the trial. The trial started on the 23rd of January. And if we look at the supplementary bundle, page 28, we can see how the defendants put their case. And
Sorry, can you give me the page again?
my lord, it's 2.8 in the supplementary bundle. This is the defendant's skeleton argument for the trial. And
Sorry,
280.
280. Thank you.
And it's paragraphs 34 and 35. And there's no criticism here whatsoever by me of the defendant. They may have failed on summary judgment, but they're still entitled to run this point again, and they're still running it today. So they say in paragraph 34, even if contrary to the foregoing, it were established that these were causing nuisance, negligent, 3 C's, that's the 3 claimants in the case, would still fail on the law. 2 points are to be noticed. One is an interference which alone causes harm to something of abnormal sensitiveness does not of itself constitute a nuisance. And then a landowner cannot complain about substantial interference with his special use of his land, caused by the ordinary use of neighbouring land, Vernon Tate. And then they say, beginning of paragraph 35, there's no dispute that the breeding of falcons in general, and gerfalcons in particular, is an activity of abnormal sensitivity. So that was at the heart of the case. And the case lasted for 9 days. At the end of January, rolling on into the start of February. There were 17 lay witnesses, 17, and there were 2 experts. And the judge sat early and rose late. The trial bundle ran to 3,600 odd pages. And there were 35 videos that were in the trial bundle, referencing the trial bundle, that were played, and more added day by day. There was a live transcription. And at the end, my learned junior, Mr. Mitchell, wrote written closings, which are in this supplementary bundle from page 288. And there's 60 pages worth of these closing submissions that Mr. Mitchell wrote during the trial and presented prior to addressing the learned judge. There were no written closings by the defendant, so we don't have the benefit of seeing exactly how it was put at the end of the trial. What there was 2 pages of headings, which is at page 348 of this supplementary. The structure of the judgment is that after an introduction, well, here, the learned judge actually has an index on page 76 of the core bundle. The second page of his judgment has got an index. And what he deals with is as per that index. Paragraphs 41 to 43 are about nuisance, 44 negligence, and then from 49 onwards is a legal analysis of nuisance. And he addresses the sensitive user case by reference to the cases Moylan and friends referred to yesterday, Eastern and South African Telegraph Co. and Robinson and Kilvert, but in the context of Tate and Fern. And there was considerable stress placed by both sides on Fern and Tate. So if one looks, for instance, at paragraph 54 of the judgment, page 90, in addressing these cases on sensitive use, which court's seen, 5 lines down in paragraph 54, the learned judge notes, Mr. Auld, he was for the defendants, placed particular reliance upon that passage in the Lord Legate's judgment. So everything, much of the legal analysis was funneled through Fern and Tate. The judge then looked at the locality principle from paragraph 56 in relation to sensitive use. And his lodestar is at the top of page 91. It's the second sentence of paragraph 56 of the judgment. He says, where the land is being put by the claimant to special or unusual use, so that he has no actionable complaint about interference with that use if the neighbour is only using his land for ordinary purposes, cannot be answered in isolation from the locality. And he deals with that in those paragraphs. And he says in paragraph 60, this is addressing the sensitivity point, although I understood part of Mr. Auld's argument to be that ROP cannot maintain a claim in nuisance because its falcons are particularly sensitive, in my judgment, therefore, Fern does not support that unqualified submission. So, using Fern, he's saying, I don't agree that this sensitive use is fatal to the claim. He then looks at Ray and Windrush, which is one of his own decisions, which is pre-Fern and Tate, but says it stands the test of Fern and Tate, and he looks at a case called Enns and he then analyses negligence, and then he reaches detailed finding about the parties' credibility. The most important one is at 189. It's about the notice point. What he finds in 189.
Paragraph 189.
Yes, paragraph. I don't know, my lady, whether it's more convenient for me to refer to page numbers or
I
paragraph.
can do either. I just need to know which track we're on, but I'm there.
It's paragraph 189.
Yeah.
I'll use both. Paragraph 189.1, he sets the stall out right at the beginning. The clear indications that the evidence of Mr. Thomas and Adrian Thomas, that's his father, first defendant's father, are sought to downplay their knowledge of the concern expressed by Martin and Scott about the impact of their company's building works on the well-being of the So, he then follows that with a detailed summary of the evidence of all the witnesses heard, as well as the expert witnesses, and results in a finding of negligence. That's basic architecture of the case. That's the basic.
Finding of nuisance and negligence.
Yes, and the basis of his liability and negligence is at 397 to 398 paragraphs. 397 to 398. And there's no doubt or dispute that he piggybacked the findings of negligence on the findings of fact that he'd made in relation to nuisance and credibility. So, unless the court wishes to ask me anything else that I may be able to help with, that's what we're saying.
Thank you.
A
Yes.
very broad helicopter view of the case. So, second, law of nuisance. This is the main bit. The reason we're doing it in this way is because one might be forgiven for saying that in Tate and Fern, English property lawyers had the arguments about the relevant principles and that a clear test emerges. And we say you can't now look at a nuisance case without looking very carefully at that case. In March 2025, the publishers of Winfield and Jollovich, which is a book that first came out in 1937, just after Donald and Stevenson, were thinking, what should we put on the front cover of our book on tort? And the answer is a picture of the Tate Modern. This is because the nuisance might be only one aspect of tort, but it was big enough to be on the. Of course, we have to do this by reference to that case. And what we say is that when you look at that case, there is a twin-limbed test for nuisance. There's two limbs, two-limb test. And the first limb is a focus exclusively on the claimant's land. And the test is whether there's been a substantial interference with the ordinary use of the claimant's land. So there's three important aspects there: substantial, ordinary, and use. Substantial interference with the ordinary use of the claimant's land. And if my lords wish to see the provenance for this, it's paragraph 21 of Fern.
I assume we're going to be dealing with Fern sometimes, so I must well get it.
Yeah, it's tab 43. I'm going to be dealing with this more or less exclusively for a little while, but there's just one other one, another House of Lords case I need to take a small tangent on. But it's paragraph 21 on page 952. And I'm using Lord Legate's speech as the voice of the majority. In applying these principles, the first question which the court must ask is whether the defendant's use of land has caused a substantial interference with the ordinary use of the claimant's land. And immediately afterwards, in paragraph 22, Lord Legate explains what substantial means. And it's normal. There's lots of synonyms that English law has in this situation. Real, substantial, material, significant. But he says, at the bottom of 952, cut the other way round, the courts will not entertain claims for minor annoyances. As Lord Wensleydale said in St Helens, Smelting and Tipping, the law does not regard trifling and small inconveniences, but only regards sensible inconveniences, injuries which sensibly diminish the comfort, enjoyment, or value of the property which is affected. So, and then he goes on to quote Walter himself, which we looked at yesterday. Same thing. No dainty modes. No dainty modes for the English. So, we looked at that passage. So that's limb one. It's a focus exclusively on the claimant's Limb 2 is a focus exclusively on the defendant's land. Because Limb 2 is, by an activity, and then there's two options. By an activity which is not an ordinary use of the defendant's land, or is not conveniently done. So by an activity which is not an ordinary use of the defendant's land, or is not conveniently done. And the references for that are, first of all, paragraph 27 of Fern on page 954. The other aspect of this core principle, that's what I'm calling Limb 2, is that even where the defendant's activity substantially interferes with the ordinary use and enjoyment of the claimant's land, will not give rise to a liability if the activity is itself no more than an ordinary use of the defendant's own land. And then paragraph 37, after he's dealt with various other cases, he talks about building, because obviously building is a big part of this area. Cases are about building, even ours to an extent. He says the right to build is fundamental to the common and ordinary use of land, involving as it does the basic freedom to decide whether and how to occupy the space comprising the property. It follows that interference resulted from construction or demolition which will not be actionable, provided it is, in Baron Bramwell's phrase, conveniently done. That is to say, insofar as all reasonable and proper steps are taken to ensure that no undue inconvenience is caused to neighbours.
Sorry, the first, as you say, the first question is substantial interference.
That's in Limb 1, yeah.
That's Limb 1.
Claimant's land.
But when you say on the second, it's exclusively on the defendant's land, in fact, at paragraph 24, Lord Legate, in dealing with the issue of ordinary use of land, first looks at the use of the claimant's land. And he says there are two aspects of what he's calling this core principle. So the first is, set out in paragraph 25, is that an occupier cannot complain if the use interfered with is not an ordinary use.
Yeah.
So it's not, the attention is not exclusively on the defendant's land. You first have to look at what's happening or what is being interfered with on the, or was said to be being interfered with on the claimant's land, and say, is that an ordinary use?
Well, that's Limb 1. That's why Limb 1 is substantial interference with the ordinary use.
I understand that, but he actually, Limb 1 is substantial, and then Limb 2, in the way you're putting it, is ordinary use, but it's ordinary use of both claimants and defendants. Well, I understand you've wrapped up part of what I'm looking at as...
I'm trying to give the court a clear test on this. Limb 2 is an activity which is not an ordinary use of the defendant's land, or is not conveniently done.
I understand that, but you've got to, when you're looking at Limb 1, you don't stop at 21 and 22, you have to look at 24 and 25. If you're incorporating within Limb 1 the ordinary use of the claimant's land.
Yes.
Because speaking for myself, that seems to be a rather significant issue for the purposes of this case.
Right.
So you draw the line after 26. You say up till 26 he's dealing with the claimant's land, and from 27 he's dealing with the defendant's.
Because of the reason I do that, my lord, is because of the words "the other aspect" in 20 at the beginning. Of 26.
Yes.
No, understood.
Yeah.
That's why I think it's Limb 2, because I think he's talking about something other.
Provided you incorporate 24 to 26 in your Limb 1, then that's all.
Fine, yes, absolutely.
But you would do that, wouldn't you? Because 25 to 26 is the flip side of the ordinary and common use, as opposed to the sensitive use. So that's the only point he's making.
Yes.
So it's got to be one or the other.
Oh, yes. It's got to be ordinary use of the claimant's land. Yeah. So, I don't think anybody argues, my Lord Justice Moylan, that this is not the right test.
I'm not saying it isn't the right test, but anyway, go on.
Well, certainly nobody on this side argues that it wasn't accurately set out by the judge in paragraphs 53.4 and 53.5. So that's page 89. And before exploring the way that the judge applied it in this case, perhaps I should just say two things. First of all, everything about this two-limb test reflects what Lord Legate in Fern described as the golden rule in this area, which is do as you would be done by. It's all about reciprocity. It's about neighbourliness. And it's about give and take. And that is embedded in both the structure of the two-limb test and in the content. So the structure, I mean, the fact that there's two limbs at all, one relating to the claimant's land and one relating to the defendant's land, reflects a central need for balance. If the claimant's use isn't ordinary, an ordinary use wouldn't be effective, a sensitive paper, then it's not fair for that additional burden to be placed at the door of the defendant. And the judge recognises that explicitly in the last sentence of paragraph 53.
Sorry, paragraph
53(4). So if the claimant's use isn't ordinary, an ordinary use wouldn't be effective. It's not fair for that burden to be put at the door of the defendant. And in 53(4), the last sentence, he says, page 89, it's contrary to the notion of give and take that a claimant should, by using his land for purposes beyond the ordinary, which carry with them particular sensitivity to neighbouring activity, increase the potential liability of his neighbour under the law of use. Correct. The corollary of that is that if the defendant's use of the land is ordinary, it's similarly unfair for it to be exposed to a liability for that use. The defendant's only using its land ordinarily. What's the problem? So, balance, neighbourliness, fairness is built into this test, in the structure and also in the content. And that's because of conveniently done, which is the second part of limb 2. Because that's specifically about neighbourly consideration. If we look at Fern, paragraph 37, which we were on, that's what it says. Conveniently done is about reasonable steps being taken. Now, there's just one case. I said to my Lord Justice Moylan I needed to do a tangent from these two, from looking at the judgment under appeal and Fern, to go to, because it's so illustrative. And it's the case of Southwark and Tanner, which is at tab 32. House of Lords case. In that case, adjoining flats...
Hold on, 32.
Sorry, tab 32, page 556.
Excuse me.
This is the flats without the noise insulation.
Yeah. So flats have been built without sound insulation, and the effect was that the neighbours could hear each other. And if we look at page 563, it's really put succinctly by Lord Hoffman at letter E. Page 563, letter E. He says it's not that the neighbours are unreasonably noisy. For the most part, they're behaving quite normally. For the flats have no sound insulation, the tenants can hear not only the neighbours' televisions and their babies crying, but they're coming and going, they're cooking and cleaning, their quarrels and their lovemaking. The lack of privacy causes tension and distress. So that's what the case is about. And the House of Lords held that this interference was not an actual nuisance because the acts complained of were both ordinary use, doesn't get more ordinary than what's described here, and conveniently done. And in relation to conveniently done, Lord Hoffman's conclusion is at page 572. 572, between letters A and B, 2 and a little bit lines down. He says, this is the essence of his reasoning. He says, likewise, it may be reasonable to have appliances.
Sorry, wait a minute. 572.
Top of the page.
Yes, got it.
Beginning likewise. Likewise, it may be reasonable to have appliances such as a television or washing machine in one's flat, but unreasonable to put them hard up against a party wall so that noise and vibrations are unnecessarily transmitted to the neighbour's premises. So in relation to conveniently done, it might be summarised. It ain't what you do, it's the way that you do it. Now, it's not that you have a TV, it's where you put it. And it's a principle that reflects the golden rule, do as you would be done by, which is what's mentioned by Lord Legate in Fern as the golden rule at paragraph 34. So I said there was two things to say about this test. The other one is, it's fantastically easy to apply in a wide variety of situations, which does give it enormous merit, especially as these things are arising in courts, which are busy and need a simple test to apply. But let's imagine a paradigm situation which one's had personal experience.
Can we put Tanner away?
Yes, please. Yes, please. So if one looks at a paradigm situation, perhaps has affected many people, but one has a child in one's home, say in a London suburban street, who's very stressed about doing an examination tomorrow. And one's neighbour is having a party. And one's child is enormously wound up. Let's apply the test. Well, then one is satisfied. This is an interference, this party would be an interference with the ordinary use of the land because the child is using the house or the neighbour. But then two, by an activity which is not an ordinary use of the defendant's land, well, it might fail that because it probably is an ordinary use of the land to have parties occasionally.
Not all the time.
Not all the time. But that's
It's not like living next to a party venue.
Yeah, that would be different. But it's
Having occasional parties is what everybody does.
Yeah.
Most people.
Yeah, but remember that Lim 2, my lord, is in the alternative. It's either not an ordinary, it's passive, it's either not an ordinary use of the land, or it's not conveniently done. So the child example is all about the second limb. They should come and tell us they're having a party so the child can go to the grandparents. But possibly should stop the party at 11 p.m. So that the adults aren't kept awake. They should possibly hold it as far away from the party hall as possible. They're all questions of fact. As a matter of fact, they're dealt with in Andrea and Selfridge, where this is worth a quick look at this. It's tab 13. We looked at it yesterday. And it's tab 13, page 192. In the speech of the Master of the Royal Sir Wilfrid Green, at the bottom of the page, four and a bit lines up. Their duty is to take proper precautions to see that the nuisance is reduced to a minimum.
Sorry, where's that?
So, bottom of page 192.
Sorry, thank you.
Tab
Yes.
13.
Yes.
5 lines from the bottom. Their duty is to take proper precautions to see that the nuisance is reduced to a minimum. There's no answer for them to say, but this would mean that we would have to do the work more slowly. We would have to do it than we would like to. Or it would involve putting us to some extra expense. All these questions are a matter of common sense and degree. And quite clearly, it would be unreasonable to expect people to conduct their work so slowly or so expensively for the purpose of preventing a transient inconvenience that the cost and trouble would be prohibited. It's all a question of fact and degree, and must necessarily be so. Well, you can see why one lingers on those words, because what I'm building up to saying is, this case is a question of fact. He goes on, in this case, the defendant's company's attitude seems to have been to go on until somebody complained. And further, that its desire to hurry its work and conduct it according to its own ideas and its own convenience was to prevail if there was a real conflict between it and the comfort. Now, the learned friend says that we're asking for unequal treatment, but that's not correct. What we're asking for is protection against the substantial interference with our ordinary use, which is the point of the tort and is limb 1. And as we will show with your lordship in the latest commission, on the judge's findings, which are not the subject of any appeal, they could have protected themselves from claiming nuisance by doing things conveniently. If they'd done things conveniently and there was still damage, the loss would be on the claim. So, if we could go in the supplementary bundle to have another look at a photo, page 113. Supplementary bundle. Let's see how it works out here.
Have you finished with firm?
Well, for the time being, yes. Thank you. Yes.
You coming back to the locality principle?
Yeah.
You are.
Well, yeah.
Because that's what seemed to influence the judge rather a lot.
Yes, he basically found that on limb 1, interference with the ordinary use of the claimant's land, you judge the ordinary by what's going on in the area. Yes, I will come back to that.
Okay.
And I would say, well, how else do you judge it? And that's what the Bermondsey...
Well, it depends on, I mean, if you switch what the judge said round, you can undertake an incredibly sensitive activity in a rural area simply because it's rural. And at the moment, I don't understand that.
Well, look, we're going to say it's a question. We're going to say it's a question of fact. Judge went, and we'll show you what he took into account.
Right. Okay.
To say that, it's. We'll show you exactly. He did take. The problem here.
Don't deal with it when you come to it.
I will. Okay. My lord, the problem here, you've got a judgment where even the judge said this is too long. There's one paragraph he said, God, this is far too long. The reader must be exhausted, something like that. And I'm exhausted. And so it's quite hard to pull it together, but yes, we'll certainly come to that.
Thank you.
So.
Sorry, we're going supplementary bundle.
I'm going to supplement just so that your lordships and my lady has this photo to see this is the claimant's land and the adjoining defendant. So the thing about this.
Sorry, which page?
Page 113.
113. Thank you. Yes.
Now this looks an unremarkable photo. What happened was there were hundreds of photos in the trial. We haven't got them here. We've only got the ones that, in breach of the practice direction, were next to the defendant's witness statements. They're the only ones we have. But this is still useful because it's the grey buildings, the area, and it's got no windows. It's got no windows on the side that, I don't think it's got any windows at all, but it's certainly got no windows on the side that abuts the defendant's land. It's got a mesh at the top of the roof. And for falcons, the learned judge's finding was that it's not about noise. Not about noise. Noise is not noise. It's about shocks. So if we look at page in the judgment, paragraph 254, which is page 134. What he finds is, he recites here, he said, Mr. Garland, that's the claimant's solicitor, said the aviary was similar in design to his own. There was his own imprint, pens were more open.
Sorry, where I've lost it again.
Paragraph 254 on page 134.
Yes, thank you.
Mr. Garland said the aviary was similar in design to his own, though his own imprint pens were more open. He said it was important that naturally breeding birds do not see out much, though it was important they can see through the roof. He explained that his own business was near a road, a clay pigeon shooting ground, and an industrial site. So it's near a shooting ground. The shooting ground's accessed via a bridle path next to his aviary, the big shooter said shot 500 vehicles. He said the shooting took place 6.5 days a week, and these birds became acclimatised to it. A younger bird moved into a new aviary will acclimatise more quickly than an older bird. And this observation, this taking from the expert evidence, did play a part, as we'll see in the judge's finding. So, point is, just looking at this picture of woman 3, the disturbance has got to be it's got to be shocking.
How do you get them used to the sound? So in fact, you have to go on using the digger all the time, so they get used to it.
Yeah.
If you use it occasionally, that's not that they're so sensitive they can't get used to it.
Yeah.
How does that accommodate ordinary use?
The reality is that once there's a finding of fact of ordinary use, you move on to Lin 2, and it's about conveniently done. So if you were wanting to use the digger next to the border,
a digger is an ordinary use.
It's an ordinary use. Of course, not in this case, because it was deliberately taken to the border, and deliberately the digger was put in the air. We know that because that's exactly what the claimant said to the defendant, please don't do the year before, and he agreed not to do. We'll see this. We'll see this. The answer is that the defendant has to say, I'm going to be doing some digging right near the border. You may want to accommodate that, in which case the older birds, perhaps who are slower to adapt, will be moved to a different side of the aviary. That's it. The younger ones can probably adapt. That seems to be the evidence in 2.5. That's how you deal with that.
I'm struggling to see how you get birds accustomed to noises. And I understand if it's going on 6.5 days a week, then they might after a time become accustomed, but to begin with they won't be.
No, well, the younger ones, of course, will be born to it. The younger ones will be born to these are sold after 3 or 4 years. They're sold to those who wish to race them in the Emirates. The younger ones, if they're born to the sound of shooting, will not find it a disturbance. That seems to be the evidence. Not about noise. It's about shock. They don't need silence. They need.
The shock point is made in 255, isn't it? That is
Yeah.
the suddenness.
Yeah, it's the sudden.
And then he makes it somewhere else as well, in reference to the airport. But he says that that's not a problem, having the airport.
Yeah.
It's there all the time.
Yeah, and that was a part of his findings, which we'll see. That's right. So the airport the judge said when he went on his site view in the judgment, he says when he went on the site view, I think it's paragraph 20, there were planes coming in from the airport. They had to stop the conversation. So it's not the noise. It's about shocks, and I suppose one gets them used to it gradually, but I can't give expert evidence on this. But that's what one would imagine, my lord, and one would imagine that the younger ones are born into. So the disturbance has got to be shocking and very high because there's no windows.
Sorry, and what?
Very high. The disturbance is, if it's visual.
Oh, I see what you mean.
A visual.
But the particulars of nuisance don't say shock noise, they just say noise. They just say excessive noise, which means more than 70 decibels.
Well, Lord, that's clearly written before the expert evidence.
Right.
And the judge made his findings on the basis of the expert. So the point is about shocking them very high, which 113 sort of helps with because there's an absence of windows.
Can I just, this absence of windows point is slightly troubling me because there was a reference we saw yesterday to blocking the western windows. And I now can't remember where we saw it. So things may have been different in 2024 when the photos are taken from what they were in 2022, which is when the claim was focused on.
My lord, I'm going to take some time. Can I?
Yeah, of course, come back to it. But just,
Yes.
I'm not at the moment clear as to what the facts as to windows were at the relevant time.
Right. Okay, I will come back to that, my lord. Thank you. So, when it comes to kites and footballs and flags and fireworks and felling trees and lampposts and CCTV on the pole, let's apply the test. So, many of these would be an ordinary use of the Defendants High Court. So they wouldn't pass the first limb, the first part of limb 2. Kicking a football is common and ordinary. It's usually going to be conveniently done. Drying clothes is going to be common and ordinary. Lampposts, maybe borderline in an agricultural area. Mushroom farm, storing manure, storing hay. These are going to be ordinary uses of the defendant's land in accordance with the first part of limb 2. But if they're not ordinary, because limb 2 is an alternative. They're not ordinary. It must be conveniently done. So,
I thought if it is ordinary, it still has to be conveniently done.
For a nuisance, in order to establish a nuisance, it has to be by an activity which is not an ordinary.
Yes.
Or not
ordinarily done, but inconveniently done.
Or not, yes. So, unordinary or inconvenient.
Yeah.
Or, so, if it's not ordinary, it must be conveniently done. And if something that might shock, like putting up a pole or flag, is on cards, then the defendant has got to act conveniently. So he must come along and say, well, we're going to be putting up a lamppost, flag. So accommodate it. In which case, it's then up to the claimant to move the older ones to the other side, do whatever needs to be done, put cloths over the cages, or do it at the other end. Do it at, say, conveniently done would be putting, if you want to put up a Union Jack, well, maybe you could put it up at the other end of the land. There are 32 acres of land the defendant has here. If we look at page 222 in the supplementary fund, this is the witness statement of Mr. Scott Nicholas, who is the second claimant. There's a plan. And the plan simply shows, outlined in red, the defendant's land. And then in blue, where the scaffolding yard it was set up. That's the subcontracted to a scaffolding business, dropping poles on poles. And then in green is the apron. So there's lots of ways in which it can be conveniently done. One of them is, don't do it just there. Do it somewhere else, this scaffolding business. You've got 32 acres.
Sorry, I don't understand that at all. Most of them are fields. How do you get to them? Isn't that close to the road?
Well, there's other road. There's other road as well.
So you're saying that the presence of the aviary dictates the manner of use of the defendant's land?
No, my lord. I say that the activity must be conveniently done. That means considerately done. And we'll see from the judge's findings, this is the critical bit, totally on the basis of the judge's findings, that he found it wasn't. And I'll show you why. Because what we're saying to the court, and this is perhaps our central submission, is that my learned friends, skillfully as one would expect, have decoupled this from, not just from Tate and Fern, but also from the facts of this case. And so what we need to do, the findings of facts, aren't seeking to go behind. So what we need to do is look at limb 1 and limb 2, and what facts he found in relation to limb 1 and limb 2 that are not being challenged. Because we, with the greatest of respect, do not have a hope of being able to find facts as compared to a judge who went on the site and heard 9 days of evidence about it. 17 day witness. We don't have a hope. So we have to rely on the unchallenged facts. So, let's look at limb 1. Limb 1, substantial interference with an ordinary use of the claimant's land. Substantial interference, we know, you can deal with very quickly, because that means there's a small or trifling impact on the claimant's land. There's no real argument here. 3 falcons died as a result of the acts of nuisance. J3, J5, and J6. That's paragraph 405 of the judgment. And it caused other birds to damage their eggs. That's paragraph 431. There's no appeal against that. The value of that was £258,000. There's no appeal against that. It was caused by the acts of nuisance.
Yes, but causative is not sufficient.
No more.
You had to show substantial interference with.
Ordinary, I'm coming to.
Yeah.
Doing it
So,
that bit.
okay.
So substantial, just doing substantial first. No real argument about substantial. There's a breakdown in here of the falcons that died as a result of the acts of nuisance and the eggs that were crushed. As my Lord, Lord Justice Moylan quite rightly moves me on.
Well, it's just saying cause effect.
The battleground here, we agree, is the battleground in Limb 1 is the argument about whether the claimant's use of its land was ordinary.
Just before, I'm sorry, we move on from substantial. You said it's substantial because birds died. And I'm not sure that's technically quite right. Because that's the consequence. And isn't the question rather on what the activities are, and whether they're more than trifling, which is not the same question as to whether the consequences are significant. You look puzzled.
My Lord, only because substantial doesn't seem to be substantial. You're now looking at Limb 2, because Limb 2 is about the defendant's land.
No. In order to get off the ground with a claim in nuisance, you first have to show that there's been a substantial interference with your use of your land. All I'm saying is that substantial seems to me to be concerned with the quality, magnitude, significance of the interference, not with what the consequences are, which you could have a relatively trifling nuisance which has dramatically serious consequences, but it would still be a trifling nuisance.
My Lord, can we have another look at paragraph 22 of Fern?
Yes, of course we can.
I'm sorry, I said I wasn't going to go back to Fern for a little while. My Lord's forced me. It looks substantial is the heading at the bottom of 952. The heading is the interference must be substantial.
Yeah.
And what is then described at the top of page 953? The courts will not entertain claims for minor annoyances. The law does not regard trifling and small inconveniences, but only sensible inconveniences. Injuries, so that's injuries to the claimant, which sensibly diminish the comfort, enjoyment and value. He then says the test is objective. It's not what the claimant finds annoying, but what an ordinary English person would find annoying. So it's the incoming effect of the annoyance. And that's claimant's land. That's Limb 1, that's claimant's land.
I don't think it's the point of importance.
I think my Lord may be looking for some sort of test of substantiality under Limb 2 when we think about
No, it's not Limb 2, it's Limb 1.
Okay.
It has to be a substantial, that is more than merely trifling. But it's an objective test.
Yeah.
So it's not the consequence of the particular claimant. If you have a particular claimant who is, in one of the American cases, there's somebody who was particularly sensitive to the sound of bells. But that's not a substantial interference, because ordinary English people, ordinary American people, are not bothered by a church bell going off occasionally. So it's not the consequence on the individual claimant, it's the nature of the interference. But that's the only point I was making. It's not, I don't think it's a point of of great significance in this case.
Well, Lord, all I'd say was that the substantiality that my Lord is feeling towards is in the ordinary use of land test in Lim 2. And that's why the bells is not. That's why the bells is not a nuisance. It's an ordinary use of the land.
No, the bells are not a nuisance because most ordinary English people don't find the sound of bells annoying. So it fails to satisfy Lim 1 as well as Lim 2. Anyway.
Okay. So I have to look at the test under Lim 1. I've got to look, because this is the battleground, at the test for ordinary use.
Yes.
And the law, it goes back to Walter and Self, but the modern treatment is in Fern. Let's go back to Fern. And it's at paragraph 40. It's paragraph 24, where my Lord Justice Moylan was before. This is the discussion of the ordinary use of land. And Lord Legate starts by saying, paragraph 24, page 953, fundamental to the common law of private nuisance is the priority accorded to the general and ordinary use of land over more particular and uncommon uses. And then there's reference to Ball and Ray. And what was happening in Ball and Ray was that in a residential street, he was using his house as a stable for horses. In a residential street. And the quote from Ball and Ray that Lord Legate sets out, just below letter F, Lord Justice Mellish, at page 471, agreed with the Lord Chancellor that, and then his analysis begins, when in a street like Green Street. When in a street like Green Street. It's all about what's Green Street like. Well, the answer was it was a residential street, but it's not an ordinary use to have horses in a residential street. And that continues, because it comes from Walter and Self, which is 1851. And that continues to be the position across the Commonwealth. That you look at ordinary use by reference to the locality. So, if we look at briefly at tab 50, the Australian, this is actually the most recent authority before the court. It is. It's the tab 50. The High Court of Australia hearing an appeal from the Court of Appeal of New South Wales. The learned friends mentioned it, Hunt leather against principle of New South Wales. And the principle is stated at 1118. So that's page 118.
1118.
1118.
Got it.
And it's paragraph 95. So it starts from the perspective of the plaintiff. So we're talking about in one. It has been established since Walter and South that a claim for interference with the plaintiff's right to land can only be brought for private nuisance if there's a material discomfort and annoyance within the ordinary purposes of life to a person's house or property. That principle, also well recognised in Australia, requires for a claim for private nuisance that the plaintiff establish a substantial interference with the plaintiff's enjoyment of land for purposes that are ordinary, in the sense that the purposes are consistent with the reasonable expectations of the locality as to the use of that land. So ordinary means ordinary in that locality. How else can you measure it? It almost reflects my Lord Justice Nugee's comment yesterday. Well, if you're not going to breed falcons in Cornwall, where are you going to breed them? Habits of living, habits of trading, which is what this is about, are therefore measured against a standard of reasonableness set by the nature of the locality. Ordinary use is within the range of what is to be expected for the land and locality in which it's to be used. And there's no challenge to that proposition. There's no challenge to the proposition that ordinary use is assessed by reference to the locality. And it's set out clearly, again, in Fern. So if my lords still have Fern open, divider 43.
Well, yes, before we leave that, what about paragraph 25? So I appreciate you're saying ordinary, but you keep using the word ordinary. But in 25, Lord Legate specifically approves Robinson and Kilburn.
Yes.
And so, when he's saying you cannot complain if the use interfered with is not an ordinary use, it's some particular trade in the adjoining property, although it would not prejudicially affect any ordinary trade carried on there and does not interfere with the ordinary enjoyment of life. And a man cannot increase the liabilities of his neighbour by applying to his own property to special uses. So where's the dividing line between ordinary and special?
My lord, what we say is, what our submission is that we accept that sometimes sensitive use stops a use being ordinary use. But the test is still ordinary use. And that is what he found. The people not protected by the law of nuisance are people not using their land in an ordinary way. The test is still ordinary, although sometimes sensitive uses make a use not ordinary. And we'll look at that when we have a look at the Robinson case and the South African case. So,
sorry, where were you going?
I was going to Fern 38, paragraph 38.
I'm sorry to go back a bit. The paragraph 95 of the Australian case you referred us to, can I just be clear as to which judgments are which? This is in a joint judgment of, I think, Justices Gordon and Edelman. Is that the majority judgment? We were told that the court split 3-2.
Perhaps I can jump up. They split 3-2 on whether Lord Legate was correct in his analysis of the principles of nuisance as opposed to Lord Sells's analysis. But all 5 judges were agreed that there had been a nuisance in this case.
Right.
And in fact,
who were in the majority on the Fern question, if I can put it like that?
yes, that they were these 2.
Gordon and Edelman.
Yes, and also
Is it the Chief Justice who gave the first judgment?
no, he was. It was Beach Jones.
Beach Jones. Thank you very much.
Yes, and can I just a slight additional thing to point out? The 3 judges who thought Lord Legate's analysis was correct, they found that the works to create the tram system were a nuisance for different reasons. Justices Gordon and Endelman thought that the creation of the tram system was not a common and ordinary use of land to give you the defence. Whereas Justice Beach Jones thought it was a common and ordinary use of land, but the works hadn't been conveniently done.
Thank you. Sorry to interrupt.
No. So I was going to Fern at 38, because the proposition I'm seeking to make a submission out of is that ordinary use is assessed by reference to the locality. And in paragraph 38, Lord Legate deals with the locality. And he says it's also well settled that what's a common and ordinary use of land is to be judged having regard to the character of the locality. He then refers to Sturgis abridgment and the famous statement, what would be a nuisance in Belgrave Square would not necessarily be so in Birmingham. And then that's the bit that the learned friend referred to yesterday. It's not a class thing he's talking about. It's about uses. It's about the locality. What's going on in the locality. And the fact that Bermondsey, a tannery, is ordinary use because it's common, whereas it's not in Belgrave Square. So, the question is, what's the position sensitive use claims. And in paragraph 24, which my Lord Justice Moylan was looking at a moment ago, and 25, leading into 25, he deals with Robinson and Calvert and the South African Telegraph case. And the interesting use of the language, which we think does assist the court, is the opening words of paragraph 25. He says, one aspect of this core principle being about ordinary use, is that an occupier cannot complain if the use interfered with is not an ordinary use. So there's no rule that sensitive users are not protected by the law of nuisance. In fact, later in firm, Lord Leggatt specifically rejects the idea of any such rule. I wonder if my lords would go to paragraphs 65 and 66 of firm on page 965. I wonder if I might ask the court to read paragraphs 65 and 66. My lords, the opening sentence of 67 is also interesting. My lord, my lady, the quote from Robinson and Calvert that Lord Leggatt highlights upon is at the end of paragraph 66. He says, if the defendant's contentions of law were really apposite, I should find it difficult to answer the query, when does an old building lose its ordinary right to protection against destruction? So I could rephrase that to match the facts of this case. And to say, when is a trade involving the breeding of falcons so sensitive that it loses its ordinary right of protection against fatal interference? I'm sorry, my lord, I've misled the court. The quote is not from Robinson and Calvert, it's from Hoare and McAlpine. It's from Hoare and McAlpine.
In this passage, what Lord Leggatt seems to be doing is drawing a distinction between the Robinson and Calvert case, which is about a exceptionally delicate trade, and the McAlpine case, about an exceptionally delicate building. And then if you read on 67 and 68, it makes the point that what amounts to a nuisance is an injury to the claimant's land, and land includes buildings. So this seems to be he says it's a false analogy to equate a delicate trade with a delicate, or equate a delicate building with a delicate trade. You are inviting us to analogize back from what he says about Horham and Calpine, about sensitive buildings, and say the same must apply to sensitive trades. And I wonder whether that's consistent with the way Lord Legate approaches it.
Well, my lord, we say that Lord Legate was looking at buildings because Vernon Tate was about buildings.
Yes.
And the proximity of buildings.
Well, it's about the fact you choose to build a building which is all glass. And the argument was, well, you can't complain if people can see into it. And he says, no, that's not right, because you're entitled to build a building that's all glass, and if people see into it, that can be a nuisance.
So he's looking at buildings, but what he goes on to say, what he talks about in 68 is the defendant's activity causing serious interference to utility and amenity values, how it's used. So trade, we'll come on to this when we talk about ground one. We say that use and utility are the same. It's all about the enjoyment of the land. The enjoyment of the land in our case is about the ability to breed falcons.
But I don't understand how that submission fits with paragraph 25, where he specifically addresses special or quotes from Cape Town case about special uses. As my lords pointed out, there's a difference between, and I speaking for myself, I think in 66, that is the distinction that Lord Legate is making by referring to an exceptionally delicate trade.
My lord, well, the question then would be, why should, if the use of the land and the enjoyment of the land is breeding falcons, why should it be any different?
Because it's a special use. It is a highly sensitive trade, and it's not reciprocity, because you're requiring as a result, the neighbouring property to be used in a way which is not common and ordinary.
Well, my lord, that's what we say.
That's the way it's being put.
But my lord, we're saying when you look at the findings of fact, we're not. Because the findings of fact were that the only things that cause nuisance were found as a fact not to be ordinary uses or not conveniently done.
But just dealing with this, the point you were making at the moment, how do you square 25 with your submission in respect of 65 to 67?
Well, the way we square it is to say that sometimes sensitive use will stop a use being ordinary. But the test is still ordinary use. And
I need to pick away this a bit because I don't quite understand how 65 to 67 lives with limb 1 of your test. Because limb 1 seems to be an ordinary and common use idea, being definitive of when there might be a claim for nuisance. 65 to 67 seems to be a sort of subsequent idea. It seems to be saying even if, in a world where you have ordinary and common use on both sides, it's nothing to the point that there may be sensitivities attached to the building. Is that what 65 to 67 is saying?
Yes.
In a building case?
Yes. Yes.
Can we come back to it? I'm like my lords, I'm just a little bit uncertain about how these propositions live together.
Right. Perhaps I could park 65 and 66 and then see if we can make it work without that. Because he's looking. This is a case about buildings. Ours is not the case about buildings. What we're saying is, if sensitive use in itself was to be a bar to a claimant's access to the law of nuisance, then no sensitive user would ever be protected. And that would mean that someone in the position of the defendants could be as unneighbourly as they like, without fear of being exposed to any liability, by reason only of the claimant's sensitive business.
Well, you say it could be as unneighbourly as they like. There is the qualification that you can be liable a nuisance if you're deliberately setting out to annoy your neighbour's sensitive trait. That's the Hollywood Silver Fox Farm case. So you can't. It's not like Bradford and Pickles where you can be malicious and
No.
set about injuring your neighbour just out of spite, or because you've fallen out with them over a septic tank or whatever. But in this case, the judge was asked to make a finding of malice and declined to do so. So we're not
Yes.
in that
We're
territory.
not in that territory. No, we're not in the territory of malice. What the judge found was that he found nuisance even without looking at malice. That's the way he puts it. So he didn't need to look at malice.
Well, he was. It was certainly on the pleadings that he did not make a finding of malice. And you can't challenge that.
No, absolutely not. What we're saying is that even sensitive users can, if their trade is an ordinary use for that locality, be protected by the law of nuisance and can expect their neighbour to act in a neighbourly way and not use their land other than for an ordinary use, and to only carry out acts that might be a nuisance conveniently. And what we say is...
Sorry, so just that may be my answer to the point that I couldn't get my head round. So you can have an ordinary trade for that locality, is the question, which is intrinsically, which has sensitivities attached to it.
Yes.
And that's still in the ordinary trade bucket rather than being in the sensitive trade bucket.
Yes. Even sensitive trades can be ordinance. Some might not be, if they're out of kilter with the locality. But if it's in kilter with the locality, it's ordinary. And what we say is, so our point is that, yes, of course, I'll come to Robinson and Kilbert and South African Telegraph, but yes, of course, sometimes sensitive use will stop a use being ordinary. But the test is still ordinary use. And that's what he found. So just before going to the findings, the learned friends yesterday referred to Brian Ribb's book, The Idea of Private Law. It's at tab 58, where he talks about hypersensitivity.
Yes.
And it's page 1307.
Yes.
And it's the paragraph in the middle of the page, which is there's only half of it on. It's called beginning similarly. Similarly, nuisance law disallows claims based on the plaintiff's hypersensitivity because they reflect the less ordinary of the parties' competing uses.
Well, he has a sort of theory of hierarchy of uses.
Yeah. But it's still the test is still ordinary use. It's just hypersensitivity can sometimes take it out of it. Now, what we submit
Is there any case in which a sensitive trade has been found to be an ordinary use?
Well, one of them is the Ems case that we looked at yesterday. This was the Hampstead playwright. So the playwright lives in Hampstead, and he's very sensitive to noise because he's concentrating all day. He succeeded.
No, but he didn't succeed. He succeeded despite being sensitive, not because he was sensitive. The judge was very clear, I'm not making my decision, in my recollection, because he's hypersensitive, but because this would interfere with anybody's ordinary use of the land. So certainly speaking for myself, my recollection is he was very clear. It was the Vice-Chancellor, wasn't it?
It was Miss Justice Plowman.
Oh, was it? Okay. Said, I'm not making this decision on the basis of his sensitivity.
Well,
is that all right?
No, he said he wasn't sensitive, and the judge didn't believe him.
Yeah.
So the judge found you are a sensitive user.
But I'm not making my decision on the basis that you're sensitive. Should we look at it?
Should we look at
just
it?
in case I'm
wrong.
wrong.
It's tab 27. 27, tab 27, page 442. So, Carlingford Road is a road of Victorian terraced houses, 3 stories high. And Ems's house was separated from the next door neighbour by a party wall. And the next door neighbour decided to convert it into 2 maisonettes. And the work was heavy work, chimney breast, removing partitions, early and late, not very conveniently done. Started early.
Yes.
Yeah.
But what I was looking at is over the page.
Yes.
And this, of course, is a summary rather than, isn't it? But there was the question, this is the middle of the substantive paragraphs, there was the question whether the noise was such as materially to interfere with the ordinary comfort, or whether it affected the plaintiff only because he was hypersensitive to noise, if indeed he was. And I know. And then in the next paragraph,
he said he was not unduly sensitive to noise.
Yeah.
The judge took rather a different view. He
Yeah.
thought that he was.
Well, he was.
Thought he was being a bit precious.
Yeah.
And then he goes on, but making every allowance for that, he was nevertheless satisfied on the evidence of the whole. A degree of noise such as to constitute a nuisance in the definition. And if you look back as to what the defendant's case was, which is the previous paragraph, the defendant's case was that the plaintiff was hypersensitive to noise and that no reasonable man would complain of the undoubted noise that there was as being a nuisance. What the judge is saying, I agree with that at all, what the judge is saying is, actually I think you are hypersensitive. But nevertheless, even if you'd been of ordinary sensitivity, you could complain.
this would have been a nuisance.
Because it crosses the line of plain and sober notions among English people. That's what... So I think my lord is right. This is an Orchid's case. He's an Orchid, the playwright. But because the other flowers would have been damaged as well, he wouldn't recover damages, even though he is very sensitive.
We still think sensitivity is a question of whether it takes it out of ordinary use.
Well, that I'm questioning, because I think it's turning the locality principle slightly, potentially, on it might be on its head, which is that you even in a locality, you cannot increase the liabilities of your neighbour by applying your own property to special uses. So it focuses on the special use.
Well, then all sensitive users are unprotected.
Except for malice.
Well, except for two things.
No, it can't.
Well, one is malice, and the other is things that would upset anybody. I mean, that's the example of the Ems case and the Orchids case. If you are committing a nuisance, it's not a defence to say you're running a sensitive trade, so I'm not liable. It's a defence to say you're running a sensitive trade, and ordinary trades would not be affected.
Well, what's an ordinary trade on this field? Well, the whole point is that the judge has found an ordinary trade is falcons. That's why it's circular.
Well, it's not circular. It's drawing a distinction. I mean, I think this is the question. You say you can have a sensitive trade which
is ordinary for the locality.
Yes, which is ordinary for the locality. It's in that bucket, it's in the ordinary bucket. Whereas I think the case you're facing is that when the cases, Fern and all the other cases, say there's a special rule for sensitive trades, it's distinguishing special uses from ordinary uses. And sensitive trades are in the special use bucket, not in the ordinary use bucket.
But that's exactly what Lord Legate says would be a nightmare to try to work out what's sensitive, other than by reference to the locality. And the finding of fact here is that it was ordinary for the locality. So it's...
No, but that doesn't, sorry, that you have to determine whether something is a special use. And that's inevitable from the structure of the test. So you can't avoid that as an issue.
Well, doesn't the question arise, how does one do that? One can only do that by reference to the locality. How do you work out that something is sensitive use? These birds are often not bothered by noise. They can be within a mile of a shooting, a few yards of a shooting range. Why is it a sensitive use? What's the criteria for a sensitive use?
So locality is the criterion usually by which you judge it, because there's no such thing as sensitive or ordinary in the abstract.
Yes.
It depends.
Yes.
It's a question of fact. Judge.
Yes, and that's what I may be wrong, because my lords weren't taken with 65 and 66 as part of my argument, but 67, where Lord Legate says this highlights the hopeless uncertainty and endless scope for arguments that would arise if the sensitivity of the claimant's property were in general regarded as giving rise to a defence to a claim to nuisance. That same concern would arise on the test that Lord Justice Nugee and Lord Justice Moylan are putting to me. How do you tell whether something's sensitive?
Well, you have to.
How? On what criteria?
Well, because otherwise, how do you apply what Lord Legate quoted in paragraph 25 about you can't increase the liabilities of your neighbour by applying your own property to special uses? So you have to decide whether that's what's happening.
Well, my lord, we say what that means is you can't bring a claim for nuisance if your use is not ordinary.
Yes, but you also
Brackets for the locale.
you say ordinary means anything that you can do. See, I think it's a bit odd saying that breeding falcons is an ordinary use of farmland. If you're asking where would you ordinarily expect to breed falcons, well, farmland is an obvious answer. So in that sense, that's what the judge means by saying there's a perfectly sensible place to put it. Where else are you going to put it? But it's not an ordinary use of farmland. The ordinary use of farmland is growing crops and raising cattle and the like, not breeding falcons.
There's other aviaries. There's other aviaries.
Of course there are other aviaries, but that's not what people normally do on farmland. And I think that when you read paragraph 25, Lord Legate's approving a principle that distinguishes between special uses or sensitive trades or not ordinary uses on the one hand and ordinary trade, ordinary enjoyment of life, ordinary purposes on the other. And you're trying to say you can be sensitive but still be ordinary.
Yeah.
I'm not sure.
Well, my lord,
That's what 25 said.
Well, my lord, we have to see why the judge thought that the ordinary use was breeding falcons. We have to see that. We have to see the factors that made him regard it as ordinary, notwithstanding that it was sensitive.
Can I?
And we haven't got there yet, because what I want to talk about is decades of aviary use.
Okay.
That's what I want. This is
just before we move on, accepting it may be that there's a language issue here, because it must be right on the Bermondsey and Belgravia approach that you can have ordinary uses which have aspects which may be sensitive, which would make them sensitive if they were somewhere else. So I don't know, you can have your tannery in Bermondsey, but if you put it in Belgravia, it wouldn't be acceptable. It wouldn't be ordinary use. Can I just go back? I think I just want to run by, please, something I've seen on paragraph 65 of Fern, which may help. It's the intro words. Remembering that the Tate case was all about Tate's user, which was not ordinary, because having viewing platform was not sensitive, but it wasn't ordinary.
No, it's a gallery.
So the intro words to 65 are about where a person is using land which is not in an ordinary way. In other words, as Tate is using it, it is not a defence in that case to say, well, the neighbour also is using it in a sensitive way. In other words, I've got sensitivity on both sides. Isn't that the point that Legate's making? Is by the time you've lost it as a defendant because you're not using it in an ordinary way, it's game over and you can't start pointing at sensitivities on the other side. That's what 65, 66 and 67 are doing.
Right. So that's
I don't think they're in the world that we're in, because where we are is in the 20s of this paragraph, looking at whether it's ordinary or sensitive judged by locality.
Maybe I accept that for the purposes of this argument, yes. So, we've got to see how the judge reached his decision, and what factors went into it, and they're all factual matters. Before I go there, can I just say before I look at the judge's findings, can I just say one thing, which is that no, forget it. Let's look at the precise way in which the judge acted and how he applied for it. There's 3 stages. The first is step 2. Paragraphs 53 and 54. 53 subsection 4. He sets out limb 1. So that's page 19. And what's notable about it is how clear he recognised that there were 2 aspects of ordinary use. One under limb 1 and one under limb 2. So 53.4 is about ordinary use under limb 1. It's claimants ordinary use. And then 53.5 is about ordinary use under limb 2. And if you look at 53.7, he says the application of the second limb of the test of lawfulness, extended to consideration of the ordinary use of the defendant's land, will therefore enable the court to reach a decision by reference to what, again, would otherwise be an insufficiently principled observation about the defendant's reasonable use. So, reasonable or unreasonable use. So again shows that he was well aware that there are 2 tests for ordinary use. One under limb 1 and one under limb 2. Then that's step 1. He sets out the law. Step 2, he considered the question of ordinary use by reference to the locality principle. That's from paragraph 56, and the key part is at the top of page 91, which we looked at a moment ago. And then paragraph 58. I wonder if your lordship...
Sorry, paragraph 58.
Yes. So he, at the top of page 91, he talks about locality principle being the centre point of ordinary use.
Yes.
And then paragraph 58 of the judgment, he deals with this sort of the discussion we've just been having. He says it's not open to the court just to categorise the claimant's use of the land as special or sensitive, without considering whether it's too sensitive for the surroundings where it's taking place. So he says, he's trying to answer the question I was rhetorically raising. Well, how do you measure sensitivity? He says you can't do it unless you look at the surroundings. And then there's an extract from 64 of his own decision in a case called Ray and Windrush. And then I wonder if your lordships would look at paragraph 65. He says, I believe these observations, with their focus upon the parties' respective uses, are consistent with the later decision inferred. One of the issues in the present case is whether or not the Avery, like Mrs. Ray's desired place of tranquility for clients staying at her cottage close to the centre of a busy Cotswold town, is to be categorised as special and unusual. That is not ordinary. And then, so he's posing step 2, he's looking at the locality principle in the context of sensitivity. You say, well, how do you measure sensitivity? It's got to be by reference to our case. And then his finding is at 334.
Sorry, 334.
Paragraph 334,
yes.
page 15. It's very dense, but it's the paragraph that counts. he says, the evidence about the location of Mr. Garland's own aviary, for my lord, if my lady wants to write it in, that's paragraphs 254 to 255. Mr. Bryn Close's aviary, that's paragraph 306, just to tell your lordships who, and my lady, who Bryn Close is. That was another person, another aviary in the area where Dr. Forbes, the expert, had done a report and there was some dissimilarities between what was being said in the reports. And it all tumbled out about Mr. Close's aviary. So, location of Mr. Garland's aviary, Mr. Bryn Close's aviary, the history of Martin's breedings of falcons at the site, for your lordship's notes, that's paragraph 192, before the aviary was built. Because Martin Nicholas did this on this site for years before, even before the aviary was built. And the overall success of ROP's business in breeding birds all point to this being a suitable location for the sensitive operation of breeding falcons. And some of what he uses to reach that conclusion is set out in the previous paragraphs under the heading the locale. So, on that same page, 329, it's a rural setting. 330, although there are buildings nearby, including homes, the aviary is surrounded by agricultural land. In 332, he says a business operation such as ROP's could of course be built in the middle of nowhere, such as the top of an isolated moor, but it does not follow that the aviary is not suited to its own location. Now, well, these are all findings of fact.
But sorry, is that the right question? That it's a suitable location for a sensitive business? Is that not turning it round? You cannot put your land to a sensitive use and increase your neighbour's liabilities. You have to decide whether it's a. I don't see that reflected in the cases. That the question is it a suitable location?
Well, what we say is that his references to a suitable location, and whether the use was too sensitive for its surroundings, were a determination by him that the claimant's use of the land was ordinary. That means reasonably to be expected for this land in the locality.
So the outcome of his decision is you can put a sensitive operation in farmland because it's farmland.
Not because it's farmland, but because of all these factors he talks to at 334, including use for breeding falcons of this area for many years. There's a range of things that go into it. It's not just that it's agricultural land. It's that it's about its location of other aviaries, two other aviaries, the history, the success of the business, the fact that it's all worked out for so long. This breeding was going on here since 2003. So it's been going on at the time of the trial. It's been going on for 22 years. It's a finding of fact, and it's a finding of fact that it was a suitable location. And the reason why it's in that language is because of the issues he was addressing in the case. Because those factors, suitable location, address the sensitive use case. But in the context of the law of nuisance, this is a finding of ordinary use. So it means that for this location, the breeding of falcons was an ordinary use and not a special use. And he decided that on the basis of all these factors and having gone round and looked. So the finding he's making is that it is ordinary. It's a common and ordinary use for this place. And he's doing it in the context of applying his mind to the defendant's sensitive use case, the arguments about sensitive use, which he's correctly directed himself to, is to be assessed by reference to the locality. And that's why his conclusion at 396 is in the terms that it is. The conclusion that their action was consistent with the fifth and eighth proposition I've taken from the decision in Bar and Biffle Waste, and with my assessment that ROP's breeding of falcons, which includes their heightened sensitivity during the breeding season, does not fall foul of the locality.
What does he identify as the locality principle? That's right back somewhere in the 50s and 60s.
The section on it begins, my lord, at paragraph 56.
He says the principle forms a central part. Where does he articulate what the principle is?
My lord, I think it's the final sentence of 56 at the top of that page. But you can't assess.
I think Lord Legate uses the phrase locality principle.
Yes, he does.
What does he say? Paragraph 38.
38.
What is a common and ordinary use of land is to be judged in regard to the character of the locality.
So, my lord, what we say is that that statement of Lord Legate is pretty much the same as the final sentence of paragraph 56 of the judgment.
And you, for these purposes, don't draw any distinction between the locality principle as it applies to the defendant's use of the defendant's land and the claimant's use of the claimant's land. Because they're two sides of the same question.
And the key point is that the application of the locality principle, which is a central part of assessing ordinary use, is a question of fact. So if my lords would be kind enough to turn up tab 40
The authorities.
of the authority, it's the Supreme Court case of Lawrence and Fenn Tigers. If my lords would look at paragraph 59 on page 809. This is spelled out.
Sorry,
Paragraph 59 on page 809 of the authority.
Thank you.
This is spelled out expressly by Lord Newburger. The assessment of the character of the locality for the purpose of assessing whether a defendant's activities constitute a nuisance is a classic issue of fact and judgment for the judge trying the case.
I'm sorry, which paragraph was that?
59.
Thank you.
So this is a classic, what he's done, this is a classic issue of fact. And what he's done in relation to limb 1, was to ascertain whether the use was ordinary by reference to the locality. And he found that it was. And that's a classic, according to Lord Newburger, that's a classic issue of fact and judgment for the judge trying the case. And Lord Sumption, Nance, Clark and Carnell agree. And that's not a finding of fact. So what he's doing in both limbs is looking at ordinary use. As my Lord Justice Nugee says, he's looking at ordinary use twice, in two contexts, both the defendants and the claimants. and he's finding suitable use, suitable location is being used for ordinary use. When it came to Lim 2, and he was talking about the defendant's ordinary use, he found that the scaffold business wasn't an ordinary use. It wasn't an ordinary use to have a scaffold business on agricultural land, which had been farmed by a tenant farmer for years. That's paragraph 18.
What was that?
Paragraph 18.
Yeah, I remember the finding.
Yeah, the scaffolding business wasn't in keeping with the rural setting of the locale, which he had from his visit. This is agricultural land, that's paragraph 14. He also makes that finding at 330, which we looked at a moment ago. Paragraph 18,
18 or 18?
1/8 of the judgment makes clear that the defendant's land was previously the first defendant's grandmother's land, during which time it was farmed by a tenant farmer. And it was agricultural land. It was for agricultural related activities. He found scaffolding business wasn't. Whereas breeding falcons was. It went back a number of years. If we look at paragraph 192, the third sentence in paragraph 192, Martin's evidence explained the breeding falcons in the approximate location of the area of the aviary is not a new venture, predates third defendant's purchase of the land by a number of years. So this was a falcon breeding area. If we look at in the core bundle at page 122, yeah, that's the bit I'm looking at. If we look in the supplementary bundle at page 21, he explains the background. Bottom of paragraph 10 on page 21 of the supplementary bundle, he said, I have used this land for the breeding of falcons since 2003. This is also where the aviaries are located, which have been in situ since 2019. Now, so the judge found, looking at ordinary use in Lim 2, that scaffolding business was not, but other things were. Dumping boulders was to create a Cornish hedge was an ordinary use. Building the barn was an ordinary use. Operating a JCB was an ordinary use. And that's certainly something that my Lord Justice Moylan may have been thinking about in an agricultural area, using a JCB as an ordinary use. But it wasn't conveniently done. And I'll see why. So all we're saying is, he applies the test. He knows the test. And he applies it ordinary land in both situations across both limbs of the test. And the two aviaries example is at paragraph 59. And we say that the court can take comfort from this. He was thinking along the right lines. What this is about, this paragraph 59, is that ex hypothesi, where there are two aviaries, the ordinary use is going to be aviary use. So the two aviaries use is not about sensitive trade at a suitable location. It's about ordinary use. And the judge is putting it in that context We can see that from the previous paragraph, 58. So my Lord Justice Moylan asked me, well, isn't he asking the wrong question? Shouldn't he be asking about sensitive trade at a suitable location? Well, what this double aviary, especially in the context of the previous paragraph, shows is that he's thinking about ordinary use, which is what he should be thinking about under Lim 1, isn't it? Lim 1. He wasn't applying a sensitive trade at a suitable location test. He was looking at sensitive trade as the corollary to ordinary use. He was imagining whether sensitive trade takes it out of ordinary use and decides that it didn't because of where it is. So, of course, we agree that if one party puts its land to a special use, that's not a burden that the other side should have to bear, whether for a claimant's or a defendant's special use. But there's no finding here which requires that. The finding that the learned friends criticise is in fact a finding as to ordinary use under Lim 1.
That's what you say the effect of 334 is.
Yes.
That there he was finding ordinary use. If you look at paragraph 58, which you just drawn to our attention,
Yes.
what he was there, the question he was posing was, first of all, you can't categorise a use as special or sensitive without considering whether it is too sensitive for the surroundings where it is taking place.
Yeah.
Only an assessment of the surrounding locality will determine whether the claimant is impermissibly seeking to. So he's looking at, well, is it too sensitive for the surroundings?
Yeah.
And so that's why he says it's a suitable location, because it's not too sensitive.
Yeah.
And you say that's the right.
That's the right way of doing it. Because what he's doing, what he's doing by that is finding that it's an ordinary use in this locality.
Well, that's what I'm questioning. He's turned something that's too sensitive into an ordinary use.
As a corollary.
Well,
I think he's asking whether it's too sensitive to see whether it's not ordinary.
yeah, well, yes, but he's saying it can be sensitive, but it's not too sensitive. Because of where it is. And is that, that's what I'm asking, is that the test? That you can put a highly sensitive business in an area,
Yeah.
and it's not too sensitive for that area.
Yeah. So he finds it's not too sensitive for the area, so therefore it's ordinary.
Well, yes.
Therefore it's ordinary, because the aviaries have been there for ages. And the two aviaries example shows how he's thinking.
And Fern says it's got to be one or the other. You've got two buckets, and you've got to put them in one or the other. So that's what
Yes.
he's doing.
Yeah. You either say this is too sensitive for the area, that's Robinson and South Africa Telegraph, or it's ordinary.
I'm not sure that's how Robinson puts it. I don't think that's why I was asking you whether it is too sensitive, because I'm not sure I've seen that reflected in the authorities. I think it's that you cannot complain if your trade is sensitive.
My lord? Many trades are sensitive in all sorts of ways. Even a playwright can have a sensitive trade.
Yeah.
It's you've just got to look at where it is. Is this too sensitive for its surroundings? Is it out of the ordinary? And if the answer is no, because of the factors at 334, which are presaged by findings of fact that go back in the previous paragraph, then it's not too sensitive for its surroundings. It's normal for its surroundings. It's ordinary and common. This is a falcon, historically, this is a falcon breeding locality. This is like the tanneries in Birmingham. So that's Lim 1, which is Claimants. Then we've got Lim 2, but for the action in nuisance to succeed, it's got to be by an activity which is not an ordinary use of the defendant's land, or not consistently, not conveniently done. And in relation to scaffolding, well, we've got findings of fact that it's not an ordinary use. Nobody goes behind. I mean, the learned friend has sought to go behind that, but I'm not sure that's in the grounds of appeal. And
well, let's for the moment. Sorry. No, you go.
If it's not ordinary use, so the scaffolding finding not ordinary use, can you just help me with how that follows through? That any annoyance that comes from is that automatically a nuisance? Or is that
No, because Limb 2 is in the alternative. So a nuisance action will only succeed if it's an activity which is not an ordinary use of the defendant's land, or not convenient.
So the scaffolding, if I'm on the scaffolding at the moment, if there was annoyance coming from the scaffolding, is there anything more, assuming the claimant's got through the Limb 1 hurdles, is there anything more to do under scaffolding apart from say it's not an ordinary use to get home?
To get home, you've got to show it's not been conveniently done.
No, you don't.
No, you don't. It's neither
if
or.
it's scaffolding, it doesn't matter whether it's been conveniently done or not, because it's not ordinary use.
I'm sorry, right.
Yeah. My lady's right.
Yes.
Provided Limb 1 is satisfied, you've got a substantial interference.
That's right. I'm sorry.
That's right, so substantial interference, that's what you need to show from scaffolding.
Yeah. You couldn't just have trivial noise from scaffolding and complain of it, because
Yes.
it would fail Limb 1. But
Yes.
if you get through Limb 1, for Limb 2, all you need to show is it's
Yes.
not an ordinary use, and you say you've found that as a fact, and that's that.
The learned friend says it was an unreasoned finding. The finding is unreasoned at paragraph 364. In that paragraph he just says, well, the scaffolding is not an ordinary use. But the basis for it is earlier at the basis for it is his findings as to the use of the land. There's two places for that. One is paragraph 18, where he noted the tenant farmer used by the defendant's grandmother. And also, it's the penultimate sentence of paragraph 60.
6A.
Where he's talking about the allegations of nuisance and say in the last 3 and a bit lines of paragraph 60, they involve claims arising out of temporary activity on UCE's land in the sense addressed above, rather than its long-term use for growing grass or crops or grazing use.
What does he mean by in the sense addressed above? What's he referring to?
I'm sorry, my lord, there was a passing play.
He says, in the sense addressed above. Where does he address this sense? What's that a cross-reference to?
I think that's about temporary. This nuisance is a temporary nuisance. Which he develops later. Develops later at 58. But what he was talking about, yes, I think 58. Yes, it's the second part of 58, I think is what he's referring to. So, sticking with Limb 2, he makes his findings about scaffolding, and he makes his findings about the building work. Now, building work he found was an ordinary use of the defendant's land. It's paragraph 382. Of course, it's ordinary use in agricultural land to do building work, but it wasn't conveniently done. And in particular, it wasn't conveniently done because it was done in breach of an understanding not to do it at that time of year. So those findings are paragraphs 359 and 395. So in 359, he finds this is about the building works. So far as those allegations are concerned, I am satisfied by reference to the evidence identified above, the previous pages and WhatsApps, that Mr. Thomas knew that both excessive noise and visual disturbances on UC's land were to be avoided during the period March to May 2022. And then at 395, it says, even though malice has not been established, the proven acts of nuisance are, in my judgment, actionable because they were undertaken without proper consideration of the sensitivity of ROP's birds during the breeding season. Mr. Thomas was previously aware.
So that is based on sensitivity.
It's based on it's not the context of this, my lord, is not conveniently done because it was known that this would be a problem, and
Because it didn't take into account the sensitivities of the birds during the breeding season.
well, because he knew that this would cause damage. So he knew that the things that he was doing would cause damage. If my lords looked at paragraph 337, there's a WhatsApp.
337.
Yes. My lords, my lady may not know about WhatsApp or use it, but it's the sort of thing where people say things that they really mean, perhaps over casually. And there's an extract from the WhatsApps from 2020. This is December 2020, so some time before. And then the last few lines of the WhatsApps. Some of this is just banter, very relaxed, thereby revealing. The third entry from the bottom, Barnes Thomas, that's the first defendant. I won't make any noise in March. He's told you'll be fine, noise is fine, it's just stuff they can see that puts them off. Unless there's a crane next to them, then you're all good. As it happens, it turns out it's pretty much exactly what he did. So, and we'll come on. So, it's not conveniently done because conveniently done is about neighbourliness and about live and let live. And the test we've seen is at Fern, at paragraph 37. It's taking all reasonable steps. And if it's conveniently done, then the loss lies where it falls, on the claim. Because the defendant will have done all that can be expected of a good neighbour. Now, how do you work out what reasonable steps are? How do you work out what conveniently done means in practice in a case like this, which is a sprawling, some might say disproportionate neighbour dispute? Well, we say that the type of things you look at are, number one, how easy would it have been for the defendants to escape liability? In other words, what's the downside to the defendant for not causing interference? And the second thing is, well, what's the upside to the defendant to cause the interference? Is it necessary for its business? And then the third question is, what's the wider context in which these assessments sit? So this is an important part of the way the judge dealt with it. Conveniently done, which is great. The question is, how easy would it have been on the judge's assessment of the facts for the defendants to escape liability? What was the downside to the defendant not causing it? Well, actually, all they had to do was carry on like they've been years gone past, in a neighbourly way, to avoid causing a nuisance for a breeding season from February to the end of May. Paragraphs 382 and 383 of the judgment make clear that the first defendant had previously agreed to avoid noise and visual threats during the breeding season and hadn't done that the previous year, only to renege on that after turning against the claimant. And my lord, my lady will have seen that what the judge says is that this huge, gargantuan piece of litigation with its 17 witnesses, 9 days in court, and Court of Appeal now, is all about a turning circle. It's about something that's completely off the page. So it starts by saying, look, this is all about the turning circle, but I've got to do it, so I'm going to apply for it. But that's what it's about. It's about the fact, he says, that there was an argument about something a bit different, because the claimants wouldn't sell a piece of land. So, when we look at how easy would it have been for the defendant to escape liability, one thing we can look at is what happened last year, previous. Second of all, the works. 383 shows there's no evidence that the need for the works to the barn was pressing. The barn building was done on an ad hoc basis by the defendant's workman, Mr. McFadden. And the judge in 383 clearly based his decision on the lack of the need for the building work to take place on those specific days. Well, if you don't need to do the work during the breeding season, and that's a finding of fact, you didn't do it last year during the breeding season, and you were asked not to and you agreed not to, but now there's a new problem with the turning circle, so you're at war. That's not conveniently done. That's not good enough.
One of the submissions made by Mr. Weeks is the effect of the judge's judgment is that his client's, or at least part of his client's land, is frozen, so to speak, for the periods January or February to April, May, and that nothing can be done which might interrupt their line of sight, might cause more than 70 decibels, which is not a very loud sound, of noise. Anything of that sort, if one's looking into the future, would be a nuisance during that period.
Well, Lord, it's just not so. And the reason it's not so is because the defendants could have avoided liability completely by it being conveniently done.
No, I'm asking you about that. Yeah. Conveniently done means not done at all, these activities which cause more than 70 decibels of noise and break the falcon's line of sight. So that means a whole raft of activities are not permissible during that period of time.
They are conveniently done. So, for instance, the first defendant should have knocked on the door and said, I need to do these building works at this time, during the breeding season. Accommodate. I'm telling you,
how does the
I'd
noise...
move the birds out, move them to a different aviary.
Is that in the evidence?
No, because it wasn't done. There's obviously no evidence.
No, I know, but the submission is that's the effect of the judge's decision.
Well,
and I haven't seen anywhere the judge saying, well, actually, this could have been managed in a different way. He's effectively said, you shouldn't have been doing it at all, because there's no other way. Inevitably, it will impact on the birds in this way if you do carry out those sorts of activities.
Well, what I said, was that conveniently done means it's not what you do, it's the way that you do it. That's what we took from Southwark and Tanner. It's not conveniently done if you put your TV against the next door neighbour's wall. So, what the judge was looking at was whether what actually happened was these works being conveniently done. And he found that it wasn't. And the reason that it wasn't, because, for instance, there was no warning, no mention, no chance for the claimants to take remedial action, no chance to move some of the older birds to the other side of the area. He didn't need to find that because it didn't arise, because it wasn't done. He looked at what actually happened and then said, that wasn't conveniently done. So he looked at the works in the barn. He said, There's no need for these works to be done at this point. You had a man who was just fitting it in around other things. Didn't have to happen then, and it wasn't in keeping with the principle of give and take to do it how you did. So, my Lord, if your Lordship, my Lord, looks to the final sentence of paragraph 383.
383.
Yeah.
Yes.
Despite their recent dialogue before the 2021 breeding season, Mr. Thomas did not think to first check with them whether this kind of activity during the period in question would result in a substantial interference with the breeding season. So he didn't even go to ask.
Well, I know, but we know the answer to that is the answer would have been yes.
Well, not necessarily. The answer would have been, don't put anything really, really, really high, and don't create shocking noise if you can. But if you have to go ahead, we'll take remedial action. But there's no findings of that because it didn't happen. We can't say that there's no findings about a conversation which didn't happen because the defendant chose not to give any notice. The evidence was that the work was being done in the early hours and late at night and in weekends. That's paragraph 369. When Karen Nicholas complained 369 to local trading standards, she said in the middle of 369 they're constantly working in the early hours and late at night, including the weekends. When they were asked to stop, they didn't. So if your Lordship looks at the finding of fact in 381, I accept the evidence of Karen Nicholas about Mr. McFadden's work on the 2nd of May. I prefer her evidence over his as to the reason why she asked him to stop work that day. It was because it was bank holiday, they were causing noise and vibration, and the birds were showing signs of distress. And then he says, at the end of that paragraph, I also accept her evidence that although Mr. McFadden said he would stop work, he carried on the work for another hour. This is not convenient. It would have been all too easy for the defendants to say, okay, so we'll do the works in a couple of months or so. And anyway, I've got 32 acres, so I'll put the digger somewhere else, not right next to your land, because I know from the WhatsApps that a crane in the the specific findings as to the digger. The digger, the findings that the judge made that it wasn't done with consideration included that it didn't break down at the spot next to the aviary. This is paragraph 385. It was towed to next to the aviary. So it's a digger that's broken down, that's crane in the air, and it's moved next to the aviary. Sorry, it was moved there and then its bucket was lifted, is the finding 385. Then 387, the last sentence, placing the digger on the bird's line of sight was entirely at odds with ensuring that no undue inconvenience was caused. 389 could have been moved somewhere else, finding the fact. And in 389, it shouldn't have been left there for 3 days, but it was bucket raised on the falcon's line of sight once it was clear it couldn't have been fixed. It was so easy. The truth of this case is it was so easy to avoid this nuisance because the defendants knew of the risk and the judge accepted findings of fact, the awareness of the defendants of the possibility of damage, which isn't challenged in this appeal. That's paragraphs 335 to 360. It's a whole section.
Okay, thank you.
Whole section, 335 to 360. On the basis of those 25 paragraphs, B5, they knew that this was going to happen. So, There's a WhatsApp conversation from December 2020. That's paragraphs 195 and 337. So 195, he accepts a verbal conversation in December 2020, talking about the breeding season, and then 337 is the WhatsApps. Then there was what's called, my lady will have seen this from the judgment, it's called the rebuttal response. What happened here was that the first defendant wrote to his own expert, Dr. Forbes, in response to receiving a letter of claim on the 12th of December 2022. And this only came to light after the trial was over. The court would see that from the paragraph 270.
Yes.
And what it showed, this rebuttal response, what the first defendant wrote to his own expert, was that he learned from his father in early May 2022 that the claimants were concerned about the birds. That's paragraph 189. It's the it's near the bottom of page 119. He wrote to Dr. Forbes, I have no knowledge that my building works were creating a problem for the claimant's breeding season until Mr. John Brady spoke to my father on 6th of May 2022. So he knew in May 2022. So the findings of fact, which cover many paragraphs, are that the first defendant knew ahead of spring 2022 of the dangers of nuisance killing with birds, and it could have been avoided. What was the upside to the defendant to cause the interference? Well, it's all about the turning circle, paragraphs 27 to 29. That's what this whole thing's about. It's all done in order. It's all done in a way that is with knowledge of the risk. And it's done in the context of a wider dispute about a turning circle which involves selling of land by the claimants. So it's not on what Moylan and friends say. Some of the submissions yesterday, including Moylan and friends' submission, this just freezes the land. It may be interesting in another context, but not in the context of this case. In the context of this case, based on the findings of fact in this case, this was found to have been done with knowledge of the risk for a completely separate purpose. And it has to be seen in the context in which the judge found it. So he found a whole campaign that explained why he decided it was all about the turnips, 27 to 29. So he talks about the septic tank claim, which my lords and my lady will have seen, which he called a highly questionable piece of litigation, where the problem was solved 2 days after proceedings were issued. It was in the context of false and malicious complaints of homophobia against the claim. And there's one other thing which is relevant, because it describes the whole nature of this case and the findings that were made and why they were made. which is that the judge finds paragraph 186, and his judgment is in measured terms. Right at the end of paragraph 186, he said it must be the case that the witnesses decided not to tell the truth in the witness. There were issues before him where he was forced to conclude that somebody had come to court to tell lies. And there are numerous findings of fact which can only be explained by the defendant having to come to court to tell lies. So, good example. We look in the supplementary bundle at page 18.
$180.
Yes. Paragraph 208. This is first defendant's statement. He refers to an email of 24th of October 22, and he says, to my knowledge, this is paragraph 208, he says, to my knowledge, this, October 22, was the first time that any of the claimants had ever raised any direct concerns with me regarding their births. Well, it's just a complete lie. Because we know from the rebuttal response that he knew in May 2002. And we've seen the WhatsApps where the concern about the birds is expressed, which goes back to December 2020, and a conversation about that in December 2020. Then there's findings in respect of Karen Nichols. If we look at paragraph 215, these are just samples. I'm not going to labour this.
Sorry, paragraph
215. I'm not going to labour this. But findings in respect of Mrs. Nichols at 215, final sentence of that paragraph. Likewise, she said that the statements by Mr. Thomas and Mr. Ambler, that's Mr. Thomas's partner, husband, that she had been in her car late one evening acting as a lookout, temporarily blocking their access while Martin cut electric fences on UCE's land, was completely false. I accept the evidence of Karen Nichols as true. The defendants came to court to tell lies. When we look at conveniently done, we look at it in the round, in the context of everything, including an assessment of what was done and what was said about it. There was a man called Mr. Brady, an elderly Scottish man, who came to mediate. Not a formal mediation. If we look at paragraph 227, the judge said, I deal with the pleaded allegations involving Mr. Brady in my findings below. Mr. Brady said it was a total fabrication, that, which is not pleaded. He had said to Mr. Thomas that he just wanted himself and Mr. Thomas in a corner of a field. I accept the truth of that. The allegations were made against Mr. Brady that he wanted violence. The judge completely disbelieved. And of course, he found that they didn't tell the truth about their knowledge of the concern expressed by the claimants. These are factors that go into the pot when we look at conveniently done. How easy was it to avoid? Easy. No evidence of any difficulty. No evidence of any imperative. What was the upside to cause the? What was the need? Something completely different to turn themselves. And what's the wider context in which these assessments sit? Defendants coming to the court and findings that their evidence was not. Lord, I was going to go on to address the individual grounds, which will be brief.
Right.
That's convenient.
Certainly. one thing that would help me is if you could deal at some stage briefly with Selfridge.
With
The Selfridge's case.
Selfridges.
Yeah, in which the Master of the Rolls preferred to guess at hotels being very easily upset. So we'll start again at 2 o'clock.
Court rise, please.